Good afternoon, everyone. My name is Marianne Goldsworthy,
I'm Elaine Remus.
and welcome to our webinar. We're both lawyers at the Legal Services Commission of South Australia. I'm a legal education officer,
And I'm a migration lawyer.
and our webinar today is about the Protection Visa Program and the best way for your clients to access our services. We don't expect you to become pseudo lawyers. However, we do understand that non-legal services are a key pathway between disadvantaged people and legal assistance services. So this session is based on the understanding that your roles combine support, advocacy, identifying issues, and referrals. You perform a key role in assisting clients to access legal help. So our aim is to increase the legal capability of community workers.
If you have any questions or you're experiencing any troubleshooting issues, please put it in the chat box and we'll monitor that. In relation to questions, this webinar is to provide information, not legal advice, but hopefully by the end of the webinar, you'll know who to contact for legal advice.
So before we begin, we'd like to acknowledge that we're hosting this webinar today on the lands of the Kaurna people, and we wish to pay our respects to the elders past, present, and emerging. We acknowledge the traditional custodians of the various lands of which we all work from today and extend our respects to any Aboriginal or Torres Strait Islander people participating in this webinar. And we, of course, acknowledge all the cultures who are participating in this webinar today. So before we begin, we might just run through some of the services that the Legal Services Commission provide that are on the PowerPoint today. But it might be first important to start by saying about why the Legal Services Commission provide the services that it does. The Legal Services Commission believes that everyone has the right to information and advice about the law and what it says. We want to make the law accessible to people so they can understand their rights and responsibilities and know how the law can affect them. We also want to help people to be able to identify when they're experiencing a legal issue and get help early.
Because of that, the Legal Services Commission provides free face-to-face legal advice to everyone in many areas of law. We can arrange and pay for interpreters. We also provide legal representation at court in some cases. So, for example, if there's a chance of prison in criminal matters or where there's a legal dispute over children in family law or in domestic and family law matters, we can provide representation.
It is important to point out that, like all lawyers, Legal Services Commission lawyers must follow the solicitor conduct rules and must keep everything they're told confidential unless they're given permission to disclose material by their clients. In a previous webinar, we have given a detailed overview of our services, and this is still available on our website. So please access this if required. In this webinar, we will be focusing on civil law, the civil law division, and the migration section in particular, and we are focusing today on the Permanent Protection Visa Program. I just skipped a slide. So having said that, one of our most important services, and if there are any legal questions you have, please contact the Legal Advice Line. This is a free information and advice service. It's available on Monday to Friday between the hours of 9 a.m. and 4:30 p.m. And as noted, Elaine has pointed out, we will arrange interpreters for you free of charge, and you can contact us if you require an interpreter through the Translating and Interpreting Service. You contact the number 131450, and then you ask for the free legal advice line, which is 1300 366 424.
If you have a hearing or speech impairment and use a teletypewriter, you can contact us through the National Relay Service. TTY users can call 133677, then ask for 1300 366 424. Speak and listen users can call 1300 555 727, then ask for our legal helpline. Internet relay users can connect to the NRS and ask for 1300 366 424. And you can SMS the relay number 0423 677 767.
So without further ado, we'll start with our topic today, which is the Protection Visa Program. And as noted, Elaine is our migration lawyer, so she's the expert today. My background is from criminal law, so I've brought questions that have come from the community and questions I have myself about the the permanent protection program, and hopefully Elaine can tell us about this program and answer those questions for us. So I might just start first of all with what services the Legal Services Commission already provide within the migration section.
Sure. So our migration section already provides some limited services for people regarding refugee and humanitarian visas. So that's if, for example, someone comes here on a refugee visa and has come here within the last 5 years and are seeking to bring over some of their family members. We can provide advice in relation to that, but we don't usually provide assistance. We can also provide assistance and advice regarding migration and visas to people who are experiencing family and domestic violence. We can go through their options with them, and sometimes we'll help them get those options.
Okay, very good. And so obviously the topic today, permanent protection visas, why is this issue so prevalent today? And what is the background to this program?
So we recently were funded by the Commonwealth Government to provide some advice and assistance and some representation for people who are experiencing a need for protection visas. So that's kind of from the beginning of the protection visa process to the end, if you want to call it that, in terms of getting advice about their prospects of getting a protection visa, all the way to representation at tribunal or court if that becomes necessary. So we provide advice and assistance, and it's been identified as an issue that we need to address because a lot of people are making these applications without really knowing the consequences of making that application. So, for example, if they're successful, a protection visa holder can't go back to the country that they've claimed protection from, and there might be limitations to their ability to sponsor family. And if they're not successful, then that prevents them from applying for any further Australian visas and even a further protection visa. So obviously there's some serious consequences either way.
That's right. Why is there such a high rate of refusal?
Yeah, so currently the government's receiving 2,000 protection visa applications a month, and over 90% of those are refused. The refusal is so high because a lot of the time when people make these applications and they do it without advice or assistance, they don't provide enough information or enough relevant information, and they also might not provide the right kind of evidence, or they might simply not be eligible.
And so that obviously means they need some legal advice, and hence this program is in place. Now, who is the protection visa for?
So a protection visa is for people who Australia has protection obligations to. And the most obvious kind of example of that is a refugee. So a refugee under the Refugee Convention and under Section 5H of the Migration Act is a person who's outside of their country of nationality, or if they're stateless, then their country of habitual residence, and who is unwilling or unable to return due to a well-founded fear of persecution.
Right. Okay. And so that forms the basis of an eligible application, this well-founded fear of persecution. Are there any things that arise, or anything else out of this well-founded fear of persecution? What else comes out of that?
Well, so if you have a well-founded fear of persecution, you would say that you have a fear of being subject to some kind of serious harm in that country that you have come from, what we call a returning, a receiving country. Thank you. Because of something that you can't change about yourself, or you shouldn't have to change about yourself. So, for example, your race, your nationality, your religion, your political opinion, or because you're a member of a particular social group, so that includes sexuality.
That's pretty harsh. And So apart from that, are there any sort of other considerations that the government is looking at when considering eligibility?
Yes. So, in short, they want to know that your fear of persecution is current. It can't be, I fled my country 10 years ago because this was the situation in the country then. This is what I experienced, and it could happen again now. You kind of have to be like, you have to show that it's still a fear that you have and
Yeah.
still a risk that you face. They have to be satisfied that you kind of avail yourself of protection measures in the country, and also that there's nowhere else in the country that you can go. So, for example, moving from maybe the risk that you're facing is in Eastern Papua New Guinea, but like you could probably avoid facing that risk if you move to the West. You have to show that that's a risk that you face in all parts of the country.
So you can move to another part of the country which potentially is safe for you to
Yes.
reside in, right?
Yes.
Okay.
And you also have to show that you don't have a right of residence elsewhere. So that includes countries that you might have citizenship in, or a right to permanent residence in. But it might also include if your country has some kind of agreement with another country that allows kind of free movement of people. So, for example, India and Nepal have what's called a friendship agreement.
Okay.
And so residents of Nepal can move to India without, like, it's free movement. So they have to show not only do they face this risk of persecution, and they have that fear of persecution in Nepal, they also have that fear of persecution in India.
The other country.
Yes.
And so it gives them quite little choice. I mean, if there are other countries that they can go to, then they're expected to go there.
Yes.
And so who makes this decision, first of all, that they can find safe haven perhaps in their own country, but then also they can go to another friendly country?
The Department of Home Affairs will make this determination first. And if an application is being reviewed, then the tribunal will make that decision.
Okay.
Yeah.
Wow. And so when someone makes initial contact with your team, the migration team, what happens at that initial stage?
Yeah, sure. So, one of our migration team members, if you contact them through email or by phone, will let you know what kind of information would be helpful to us in setting up an appointment. Probably the most important information to give them is whether there's any kind of critical dates coming up. So, if a person's visa is expiring, or they have a tribunal date listed or a court date listed, then we'd want to know that, because that kind of depends on how quickly we can get them into an appointment.
Yes.
We'd also want to know things like what visa status they have. So whether they have a visa, what kind of visa it is, what subclass, when that visa is expiring, and also whether they came here with any family, or have come alone, or that kind of thing.
I was going to ask if there are any waiting lists, but perhaps you might have answered that question when you talked about the information that's required to determine how or when the appointment is with those critical dates. But I still might ask it. Are there any waiting lists?
Yeah, so it really depends on how urgent it is. And it's kind of a decision that will be made by the migration team member with that kind of information, but based on the responses that they get to what they've asked for. Yeah.
And you mentioned the information about what else is required when they come to the appointment. We talked about information about the visa, and is there a way that they might be able to get this information themselves that might help the appointment?
Yeah, so we've got this slide up that says that talks about a Vivo check. So that's just an online that kind of check that the Department of Home Affairs through the migration section of their website has put online and is available to visa holders, employers, education providers, and other organisations to check someone's visa conditions. So we often will, it would be best if you could get, if you or your client could get their visa details from the Vivo check prior to the appointment and just email that through to us, because it kind of answers a lot of the background questions we'll have about their visa and expiry and their status as well. And also it's just a lot simpler if the visa holder themselves or someone that can be with them gets that information. So you can just access it through the Home Affairs website. Make sure that they have their travel document with them, as well as like their visa grant number. And then it'll generate the Vivo check and you'll get all of that information.
That's good to know. Okay, and so now that they've got that visa information and they have their initial contact with you, now they've booked their appointment, what further information or what's to be expected from that face-to-face appointment that they will have with you?
So we would confirm their current visa status. Would probably go through the Vivo check, see if there's anything else that is missing or is not clear to us. And then we will ask the person attending the appointment questions about their protection claim. So we would ask questions like this. So why they can't return, what they think will happen to them if they do, why that will happen to them. So why they feel like they would be targeted, whether they've experienced any harm previously in that country, whether they were able to access help for that harm, whether they feel like the authorities can help them and why not, and whether they can relocate elsewhere in the country. So just covering all those bases that we talked about earlier. And then after we've gotten that information, we'll give them advice about their next steps. So if they haven't done a Vivo check, for example, what we might do is ask them to do that. So that's why I've kind of said it's best if they do that first.
That's right.
But it might be that we're like, okay, actually, maybe a protection visa isn't quite right for you, but maybe you can talk to a migration agent about perhaps a student visa or a skilled visa. Or we might say, we think you're eligible for this. We think this is probably the best option for you. Why do you want us to help you? And then from there, depending on kind of where they're at and what we think they should do next, we might help them apply for legal aid or tell them how to do that themselves.
Okay. So obviously all this information is relevant to trying to answer that question about eligibility, and it's a lot of information. And we talked earlier about this program is funded by the Commonwealth Government. So one of my questions is, what do you do with this information that you collect? It's a lot of detailed information.
Yeah, we like you said earlier, we're bound by the same obligations as every other lawyer. So we don't provide any information to anyone unless instructed to do so by the client. So this information is just, we'll take notes during the appointment and we'll store them on our system, but they don't go to the department, they don't go to the tribunal, and they don't go to the court unless we think that it needs to, but then we would always ask. And we wouldn't do anything without
the client
knowing.
Yes. I think the reason I ask the question is because obviously there might be a misconception that because it's funded by the Commonwealth Government, that perhaps the information might be filtered back to them somehow. And so I guess that answers that question, that no, it's completely independent.
Yes.
So that's good to know and good for the clients to understand that separation. And so to recap, you seem to have identified that there's three processes in this program, or in the application for a protection visa. There's the application to the department, and then there's a tribunal stage, and then there might be a further one if it's at an appeal stage. Where does the Legal Services Commission fit in terms of applying in terms of assisting a client?
So we can assist at any stage of the process. Certainly, I think that people should feel free to get advice at any stage of the process. So if they're even just thinking about, like they're wondering what their visa options are and whether they're eligible for a protection visa, that's a great time to get legal advice before anything's lodged. But if there's already one in progress, and the department has asked for further information, we can jump on board there and provide some advice, and maybe some assistance. Or if the visa has been refused either by the department or by the tribunal, they can come to us and get some advice about their next steps. And in certain cases, we may be able to represent them in the next stage of their matter.
Okay. And in terms of these 3 different processes, what are the cost implications for a client?
Yes, so an application for a protection visa would be made to the Department of Home Affairs, and lodging that application costs $45. At the tribunal stage, you can it's free to lodge an application, but if you're unsuccessful, you do have to pay within 30 days. The AAT, I think the fee is $2,151.
Wow.
Yeah, and then for the federal court to even lodge an application in the federal court for appeal of the tribunal's decision, that's $5,705.
Wow.
And then on top of that, if they're unsuccessful at the federal court, they would be liable for the cost of the government's legal representation and that kind of work, which is probably around $8,000 to $10,000. So it's not
very significant.
Yes.
Yeah.
It seems like a cheap application at first because it is the $45,
that's right.
but you go down this road and the costs can rack up.
So can you tell us the difference between the tribunal and the court phase? Because they obviously are very different and the cost escalates quite significantly when you get to the court phase.
Yes. So at the tribunal can look at the Department of Home Affairs decision. So if you have had your visa refused for some reason, you can apply to the tribunal to have them look at your matter again, look at your application again, look at all the evidence again. They'll interview you basically in what's called a hearing, and then they'll make a decision about whether they should grant you a protection visa, or your client a protection visa based on kind of the merits of that claim.
Right.
But for court, it's a much narrower kind of what we call grounds of appeal, because you have to show that there was something wrong with the way that the tribunal made the decision.
Right.
So it could be because they showed some bias against you, or they came to some conclusions based on evidence that you didn't present, for example. So, but you can't say, the tribunal made the wrong decision because I do have a protection claim. It's not. They can't look at kind of whether that decision was right. They just have to look at whether it was made correctly.
That's right.
Yeah.
That's interesting. And so I can see why people should get advice, because the costs are really high.
Yes.
And are there any, I know with some matters, there are timeframes that people need to appeal matters. Are there any in place for protection visa appeals?
Yes. So after you're refused a visa by the Department of Home Affairs, you have 28 days to put in a review at the Administrative Appeals Tribunal. And you also have 35 days before your visa gets cancelled, and we'll talk. I think we should circle back to that in a second. And I think it's the same after an AAT decision. You have about 28 days to appeal that.
Right. Okay. So 28 days to get in some advice and an appointment before you are out of time, and then you can't make an application.
That's right. Yeah.
Okay, that's quite interesting. And so this 80-90% refusal, and that's really because a lot of the time there's no advice, and if there was, you think that might impact Well, we certainly hope
We
so.
hope so, yeah.
Now, we also talked about the time frame that the question is, are there time frames between the applications, between the applications to the AAT,
Yeah.
or from the tribunal to the AAT? What are the time waiting frames for people?
Well, if you go through the whole process, we see people quite commonly waiting for a final determination for 5 to 10 years. So
Wow.
it can be very lengthy, and that's a long time to spend in limbo. The other thing is that when you put in an application, once whatever visa you had prior to that application expires. So, for example, if you had a student visa and then at the end of the student visa, like maybe 10 days before that expires, you put in an application for a protection visa. Once that expires, you will be on a bridging visa. And a bridging visa is what we call, well, it's not a substantive visa. And you might not necessarily have work rights. You might have no study rights. You might have limited work and study rights. If you want to be able to travel out of the country and then return, you're going to need to apply for a particular bridging visa. And so it can be quite restrictive. And so that's 5 to 10 years of being on a very restrictive kind of visa.
Yeah, it's a very long time. And so you would need some advice about, when you lodge this application, what will your interim visa be? What are the conditions of that visa? What will it look like? In particular, if you can't leave the country, or what happens to family members in the meantime? Okay, that's interesting. Now, so we talked about these fees that happen at tribunal, the cost of the application of 45, and then that 2,000, and then that 6, and possibly plus the cost of the prosecution fees. How does the Legal Services Commission fit into the fees for the applicant?
We don't pay for any of their application fees or any court fees or anything. We basically are funded to provide the lawyers. So we provide that advice and the representation and the assistance for free, sometimes dependent on legal aid. So that would all of those costs that I just listed before would be fully borne by the applicant.
Okay, so we provide the lawyers, and the cost of the application and the appeal are borne by the client. That's really important to know. Do we have a question? Okay.
Yeah, so Lauren's just asked what community financial help, is any, is available to asylum seekers who can't afford the cost of tribunal fees. That's really timely.
Yeah.
That's hard for us to comment on because we don't necessarily have any partners who can do that. But I think I believe maybe the Australian Refugee Association might be able to point people in the right direction on that front. But I don't know what eligibility is for that. So, yeah.
And it's very hard when you hear how much it costs.
Yes.
It's particularly high, and particularly if you are refused. And if you are not only refused at tribunal, but at court, who has that kind of money? So if we find out, we can update, but at this stage, we don't have the answer to that question.
Yeah.
Okay, so initially we talked a bit about how sometimes this is crossover between migration and family and domestic violence, and how the migration team assist in that area. Can you give us a little bit more information about that sort of cross-section?
Yeah, sure. So the Department for Home Affairs recognises quite a broad definition of domestic and family violence, which includes coercive control. And so we can have people who are worried about, they might not have experienced, physical abuse, but they might have been told by their ex-partner that their partner is going to cancel their visa or have their visa cancelled. And so we exist to basically allay those fears and say, no, that's not something that's within a visa holder's power. It's only the minister who can cancel a visa. And then we can kind of provide them with some options going forward from there. So if someone's experiencing control, manipulation, abuse, and they are worried about their visa status, we can help with that.
Okay, very good. And I might just talk more broadly about how, aside from migration issues, how the Family Violence Unit assists more broadly women who are subjected to family and domestic violence. So we have two services that we provide. We have the Domestic Violence Unit, and they are a service that have quite a broad remit. They assist women in relation to many legal issues that domestic violence can give rise to. And when we say domestic violence, we are talking about violence from a intimate partner. So, for example, a woman seeking to protect themselves from future acts of abuse, they can assist with advice and representation in court in obtaining a protection order, what you or your clients might know as an intervention order. Or if the person wants to make an application to have their name removed from a tenancy so that they're no longer liable to pay rent or any damage at their property, the team can assist with an application and advocacy to the South Australian Civil and Administrative Tribunal for this to occur. This is something that happens in family and domestic violence matters. They can also assist with family law issues in relation to separation or obtaining parenting orders, and they sometimes may be involved in pursuing an application for legal aid, and we can talk about this when we talk about Woodfocus. They have success in having debts partially or wholly waived, assisting with minor property disputes and the return to property. So in seeking to have a broad scope to assist, this service also has a dedicated mental health support worker in the team to work alongside the lawyers and assist clients in recognition of the fact that social and legal issues are often heavily intertwined. So this service sits quite closely together with those support services to assist women. They have a specific number that you can contact aside from the legal's advice line that you can always contact, but they can also be contacted on 8111 5511, as well as an email address on the slide, fsis@lsc.sa.gov.au. While the legal issues they can assist with are broad, they're funded to assist women in the northern suburbs and outreach to Port Augusta, Whyalla, Port Pirie. So they do have a geographic limitation to those areas. But of course, there is another service that we also are able to provide, which is the Women's Domestic Violence Court Assistance Service. So this is not so geographically limited. And this is not just limited to a woman who is being subjected to domestic violence by an intimate partner, but this is also a woman who is being subjected to domestic and family violence. So this is violence by family members and not just an intimate partner. And this is a service that's available statewide. It's legal assistance that's provided. It's focused on helping women, not only with intervention order, but tenancy issues, some of those things that I talked about before. They also provide referrals where other legal issues arise, and they can provide referrals again to mental health support teams. So again, trying to get a more holistic service in place, noting the issues that are normally at play in relation to family and domestic violence services. And like the DVU unit, it's a free service. It's not subject to any means test, noting the difficulties in this area. And this service can be contacted through the helpline, or you can contact them directly on 1-800-246-642. We also have, for the protection visa program, some specific posters and brochures that are available in English and 11 other languages. We have them available in Mandarin, Vietnamese, Hindi, Malay, Urdu, Tagalog, Indonesian, Thai, Fijian, Arab, Spanish, and Persian. So they're available. You can write in to the Community Legal Education team on cle@lsc.sa.gov.au if you want us to send you out some that you want to distribute, whoever you think might receive them well. We're happy to send them to you. Would like as much exposure to this so that people are aware of the service that we're providing. so that Elaine's team can help. So please get in touch. Let us know if you'd like some. Let us know if anyone is interested, and we'll happily send them to you. In addition, we also want to let you know what our next webinar will be covering. The next webinar is on the 31st of October 2024, and it relates to the changes to residential tenancy laws. So please tune in, and hopefully that one will be a good one too. So that brings us to the end of our, I think we have a question.
We have another question. So does the Legal Services Commission do any systemic advocacy on migration topics, so contributing to inquiries and advocate to the government? If so, what are the key topics LSC are advocating on at present?
In terms of is it just for migration?
Yeah, this is specifically migration. Sometimes we're invited to make submissions in relation to various inquiries by the government. So the Legal Services Commission is, for example, invited to make comments. I think one of the last things that our team was invited to comment on was my team being the Civil Law Division, not the migration team necessarily. It was the Mental Health Act review. And so I imagine that if there were similar inquiries being undertaken which touch on our work, that we would be involved in that. But in terms of kind of seeking out advocacy opportunities, that's probably not a question for me. It's probably a question for a bit higher up. Were there any other questions while we're here? Oh, cool. Great. Well,
yeah, I think that wraps it up. And if there's anything that we want to leave with you today, it's the information and advice you can get by contacting the legal helpline on 1300 366 424. It's free, it's accessible, and we hope that you can use it. But we really want to thank you for tuning in today, and we hope you enjoy the rest of your day.
Thank you.